So nice to see you again. I'm Steve Levinson, a retired Supreme Court Justice from Hawaii.
And Judge Murray.
I'm Hank Chambers, and I'm a law professor at the University of Richmond.
And if you'll introduce yourselves, please.
Hi, we're Unit 5 from Arcadia High School in Arcadia, California. Our unit focuses on the Bill of Rights and its modern applications. Before we introduce ourselves individually, we'd like to take a moment to acknowledge our teacher, the fantastic Mr. Fox. I'm Rola Long.
Hi, I'm Greg Chen.
Good afternoon, I'm Lauren Hanna.
Hi, I'm Kiko Sinada. Good afternoon, I'm Paloma Bota.
Okay. Look forward again to an exciting dialogue. This is an interesting question that is going to involve the future, and you all are going to be making these decisions. And we're going to discuss question number 3 today. We need procedures that translate the values of Fourth Amendment with its warrant requirement into a new technological context. Do you agree or disagree with this claim by a legal scholar? Why? What values are inherent in the Fourth Amendment and why are they important? Some scholars argue that government can use surveillance, data collection, and data mining technologies for good purpose, such as keeping America safe from terrorist attacks, preventing crime, and delivering social services. Do such uses outweigh possible negative uses? Why or why not? And you may begin.
In Olson versus United States, 1928, the Supreme Court ruled that wiretapping did not constitute a search or seizure. Chief Justice Taft ruled that because the Fourth Amendment did not explicitly prohibit it, warrantless wiretapping was unconstitutional. In 1967, the court reversed its ruling in Katz versus United States, noting that phone conversations warranted protection due to a reasonable expectation of privacy. We agree with the court's holding in Katz and believe we need procedures that will continue to translate Fourth Amendment protections into a new technological context.
The Fourth Amendment says that people have a right to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. Today, persons should be extended to protect DNA, facial recognition technologies, and other means of surveillance that gather information from the human body. Similarly, papers should now include emails, web pages, and even text messages.
We believe that failure to modernize and adapt the Fourth Amendment would jeopardize due process rights. Therefore, we have created a 3-pronged test to be applied by the courts that manifest the intent of the Fourth Amendment in a new technological age.
1. The individual must have a subjective expectation of privacy. That is, he or she honestly assumes that a certain place or situation is private. That being satisfied, 2. The individual must establish, based on contemporary community standards, that there is an objective, reasonable expectation of privacy. If the first 2 prongs are met, then 3. The government must establish that it satisfies the warrant requirement or any applicable exceptions.
If the government fails to do so, the legally obtained evidence will be deemed inadmissible in court according to state or national standards. For example, in our home state, California Penal Code 1538.5 outlines the method by which a defendant can move to suppress evidence. On a national scale, this protection is known as the exclusionary rule. According to John Locke's Second Treatise on Civil Government, Chapter 4, Section 87, no political society can exist without having the power to preserve the property of its people. Inherent in the Fourth Amendment is a preservation of such property as achieved through protection of privacy and protection from arbitrary governmental invasion. According to Locke, people enter into a social contract by yielding their powers to the government in exchange for security of their inalienable rights of life, liberty, and estate, collectively known as property. In Section 111, Locke describes the need for the people to find out ways to restrain the abuses of their power, which they have entrusted in the government's hands only for their own good. Thus, we see that inherent in the Fourth Amendment is the preservation of the social contract, and thus the preservation of democracy.
We believe that government can effectively use warrantless surveillance and data collection for certain limited purposes. However, warrantless surveillance is too susceptible to abuse to be readily allowed.
For example, in a current litigation, Hepting versus AT&T, Hepting challenges AT&T's cooperation with NSA in allowing the installation of supercomputers capable of collecting personal data from thousands of customers including all domestic numbers dialed and all web addresses visited since 2001. The government put forth a state secret privilege in order to dismiss the case under the pretext of national security.
We strongly disagree with the dismissal of this case under state secrets because it undermines checks on executive power by preventing judicial review. In Al-Haramain versus Obama, Judge Vaughn Walker of the U.S. District Court agreed, ruling that the state secret privilege led to unfettered executive branch discretion that has obvious potential for governmental abuse. We believe that if the government has a compelling interest to violate the privacy rights of citizens, then it should be willing to submit to judicial scrutiny to prove that its actions are justified. Thank you.
Is it your position that surveillance cameras and videos in public places should not be allowed? Is that the position?
Well, we acknowledge that surveillance cameras could have good purposes, such as we see in the London Ring of Steel, for instance.
Yeah, but is that your position, though, that should not be allowed?
Well, we think that if we were to allow such things, then they could be easily abused, as we've seen with the Patriot Act, and also with the recent example of the Department of Justice versus Yahoo.
Okay, so then what would be the difference between a videotape and somebody coming up and taking a picture of you? You know, and is your face private?
Personally, I disagree with the contention that video cameras in public would be a constitutional violation of the Fourth Amendment because we see that video cameras have been used historically to provide important crime-fighting data for police. For example, in London, they have extensive video cameras covering nearly every street corner, yet the citizens report that they approve of the use of cameras 90% of the time, and 95% of those surveyed wanted even more cameras because it made them feel safe.
Let me ask the question this way. Let me ask it this way. Under what circumstances do you believe that governmental warrantless surveillance and data collection is justified under the Fourth Amendment?
I think it's justified, right, if there's a national emergency occurred, such as 9/11. However, I wouldn't extend the period of warrantless surveillance to years. Rather, I propose in a few months, essentially because of the fact that after a terrorist attack, often you can use surveillance to attract economic transitions.
I would say that
I kind of agree with Greg in the point that national security is a basis on which you can warrantless surveillance people. However, I disagree with the contention that you can use state secrets privilege to dismiss a case as they did in Hepting.
I agree. I believe that the state secrets privilege has undermined the compelling state interest of the government in national security. Because with state secrets, you see that evidence essential to a case is being dismissed. Therefore, the executive branch is no longer responsible to prove that it had a conflict of interest because the cases never go to trial.
I believe the only time